How y'all doing? So we're going to be talking today about the lawsuit that 50 wrestlers took against WWE. The class action lawsuit is about concussions and CTE. Essentially, that these wrestlers claim that WWE knew the dangers of head injury and concealed them. It's similar to the lawsuit that the NFL and I believe the NHL, I believe hockey had the same problem. This case was dismissed, and then the plaintiffs they appealed the dismissal, and that appeal was also dismissed. So we're going to read some documents because it's very necessary that we read documents so that people can actually go to the source. And of course, as usual, with the exception of one document, we will be putting as many sources as we can in the description. So there's gonna be a lot of reading. So I hope you strap in. I don't know how long we're gonna be here. So the first things first. Big Vito, who wrestled in WWE as Big Vito, his real name is Vito Lograsso. He posted a statement about the dismissal of the case on Twitter. He added every wrestling journalist that he knew, from Fightful to Pro Wrestling Sheet to Alvarez to Meltzer, everyone. And what the attempt, of course, to get attention for this case. Now, I'm almost certain that the reason why I'm doing this video is I'm almost certain none of them will actually post what happened in the court case. This is where we're going to go through this, okay? I find it very important that people go to the source of information and don't just take people's word for it. So we're going to read Big Vito's statement. We're going to read that first, and then we're going to find the dismissal papers, which should be online. We're going to read those, probably not in full, but we're going to read enough of it to get a general sense of what took place. And then we're going to read a little bit more. Then I'm going to give my thoughts. I don't know enough about concussions and CTE to venture an opinion, but I do know, a little bit about people trying to be dishonest or misdirecting things. And this is how you keep people honest. It's that simple. I'm not saying who's right or who's wrong. I'm just saying you have to keep people honest. And sometimes people are lying. Sometimes those people are Vince McMahon and WWE. We'll see. I have not read all of these documents in full, by the way. It is just too much to read. Court documents are incredible. It's got to be. It takes, a team of people to read court documents. So we're going to read probably enough of it to get a general idea of what took place. Okay. It should be pretty simple. I used to read court documents in college. I used to also read, research papers. So I know, I understand this stuff, to a degree. So let's start with Big Vito. So Big Vito writes, "It is true the good guys don't always win, but they never stop fighting. Unfortunately, as a first-generation American and a voting American citizen, I was denied my right to a hearing. I was not allowed to present my fight with a jury of my peers. My case versus WWE in the district court level went the distance. Depositions were recorded, thousands of forms filled out, thousands of dollars for filing fees. We went into settlement talks. As we were awaiting a hearing date, Judge Bryant dismissed the case. It was dismissed on the basis of something 100% unrelated to me whatsoever. But again, as an American citizen, I knew I had my right to appeal, and due to our court processes here in the U.S., I waited years for that right, and in 1 pound of a rubber stamp, my rights were thrown out of the window. What makes me have less rights than others? Because I'm not a politician, I have no rights to a hearing. Because I'm not a Fortune 500 company, I have no rights to a hearing. Because the job title pro wrestler isn't as glamorous as NFL player or Hollywood actor, I have no rights to a hearing. During the 6 years of fighting for wrestlers' rights, we have lost dozens of our brothers to CTE and brain trauma-related deaths, overdoses, and suicides. Myself and my family went through constant harassment, death threats, hacking of our websites and social media, personal information about our family released, information about my wife's medical condition, and we were doxxed, which resulted in us selling our home and moving out of state. Our lives have been changed by CTE, not only the effect it has on our personal family, but also our friends and loved ones. We suffered through the loss of our dearest friends in a murder-suicide directly related to CTE and professional wrestling. Sadly, this isn't the first time we experienced this. We have been fighting, so it will be the last time we experience this. Vince McMahon and the WWE have done nothing to assist with the plight of pro wrestlers who have worked under their banner. A quote-unquote drug rehab is a band-aid on a gaping wound. They have made millions off the backs of men and women and watched us as they have fallen to injury and illness as a result. These men and women breaking their backs for you are not afforded health care, security, recovery time, retirement benefits, fair treatment, licenses, and royalties. It's to the point they can't even use their legal names without the company claiming ownership. Being an independent contractor, quote unquote, affords them an unhealthy, quote unquote, indentured servitude. And after time served, they are thrown away like human refuge, and the situation has only gotten worse. And to Linda McMahon, formerly administrator of the Small Business Administration, as independent contractors, we are small business. You are tied to not only the company, but the government. What have you done to help? What have you done to make a difference? I have contacted several major wrestling companies to discuss safety of pro wrestlers. I have been contacted back by none of them. I still have an open door policy to have an open discussion about wrestler safety and rights to any company that wishes to discuss this topic. The fight was never about money. More money has been spent than would ever been recouped. This is about change. This is about respect for professionally trained athletes who are suffering and those who are making money off of this suffering. This fight will never stop. I want to thank Andrew Yang and John Oliver speaking out on our behalf. I want to thank my lawyer, Mr. Kyros, for his tireless work. I want to thank friends and fans for standing by us. Again, as an American citizen, a son of immigrants, I believe anything is possible. I believe change is possible. Our case was already named in a victory in Ohio Appeals Court, Schmitz versus NCAA 2016, Ohio 8041. And we will not stop until we are heard. Vito J. Lograsso, CTE and human rights advocate. So that's it. That's a Big Vito statement. So, as per the usual, I'm going to go through this a little bit, and I'm just going to poke out some things. For starters, we can see here that he just pretty much piggybacking off the Andrew Yang and John Oliver stuff. Two guys who have never done shit for wrestling except use it to get themselves to curry points with the wrestling media. So that should already be a red flag. Second red flag is he started talking a lot about different things that happened to him that probably have nothing to do with this case. For instance, myself and my family went through constant harassment, death threats, blah, 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 blah. Unless you can say that is related to this case, I don't see how that's relevant. That sucks, period. But are you saying somebody from WWE doxed your family or harassed you or sent death threats to your family? If that's the case, that's a completely different ball game, right? So there's a lot of different things here. Again, I don't believe that they do enough about CTE. But then again, I don't know enough about CTE to make that opinion. I just say, hell, try to make it as safe as you can, because pro wrestling is inherently dangerous. Just like football, just like hockey, it is, collision. It's a collision sport, just like the UFC. It's all about, people banging fists apart across people's heads and falling down. So yeah, you're going to have brain injury. It's going to be, now you would think intuitively that, power driving each other and throwing each other through tables and hitting each other in the head with steel chairs would have long-term damage. You would think that intuitively, but nobody knew really about CTE until it popped up and it came up. I forget what year it showed up in, but that's really when it became a big deal. So this is the Big Vito situation, all right? What we're going to do now is we're going to go to the court case, and we're going to see why this case was dismissed. We're not just going to say that, quote unquote, they have no rights, okay? That's vague. It doesn't mean anything. The case was thrown out for a specific reason. So let's go find out what those reasons are. All right, so this is from the United States District Court, District of Connecticut. This is the consolidated case of all of the people who are suing the WWE. And what this is a memorandum of decision granting defendant motions for judgment on the pleadings and to dismiss, and granting in part and denying in parts defendant's motion for sanctions. Okay, so I don't know how much of this we're going to actually read, but strap in, because I'm in this for the long haul. I'm very interested in this stuff, and I gotta know. I gotta know. I think if you clicked on this video, you have to know too. You want to know what's going on. So, part 1, introduction. On September 29th, 2017, this court issued an order regarding a motion for a judgment on the pleadings and motions to dismiss and for sanctions filed by WWE and Vince McMahon, collectively known as the defendants. The order directed counsel for the plaintiffs in the Laurinaitis action, Laurinaitis plaintiffs, and the declaratory judgment defendants in the Wyndham action, DJ defendants or Wyndham defendants, collectively plaintiffs or wrestlers, to, quote, file amended pleadings which comply with federal rules of civil procedure 8 and 9, which set forth the factual basis of their claims or defenses clearly and concisely in separately numbered paragraphs. In order to assist plaintiffs' counsel to meet their theretofore unsatisfied pleading obligation, as noted in the court's prior rulings, and to mitigate any potential further prejudice to the defendants, the court also required the wrestlers' counsel to demonstrate that they had conducted factual due diligence in preparation for filing an amended complaint by, quote, submitting for in-camera review affidavits signed and sworn under penalty or perjury, setting forth facts which each plaintiff's or declaratory judgment defendant's personal knowledge that form the factual basis of their claim, including, without limitation, 1, the date or dates on which they wrestle for WWE or any of its agents or affiliates, including the first and last date. 2, if they wrestle for more than one person and or entity, for whom they wrestled and for what period of time. 3, whether they ever signed any agreement or other document in connection with their engagement to wrestle by or for WWE or any of its agents or affiliates. 4, whether they were ever or are now in possession of any document relating to their engagement to wrestle by or for WWE or any of its agents or affiliates, including without limitation W-4s, W-2s, or 1099s. And number 5, what specific WWE employees or agents said or did that forms the basis of each and every one of the claims or defenses in the wrestler's pleading, including A, a reference to the specific paragraph of the complaint, B, when and where such act occurred or such statement was made, C, the identities of any and all persons present at the time of the act and or statement, and D, any and all other facts personally known to the affiant that form the basis of their belief that WWE or any of its agents or affiliates knew or should have known that wrestling caused any traumatic brain injuries, including CTE. The court reserved its judgment on pending motions to dismiss, for judgments on the pleadings, and for sanctions to give the wrestlers a final opportunity to file pleadings that complied with both federal rules of procedure and the order. The wrestlers filed a second answer to the Wyndham action and a second amended complaint in the Laurinaitis action on November 3rd, 2017. The wrestlers' counsel also submitted for in-camera review affidavits for each wrestler. After reviewing each of these submissions, and for the reasons that follow, the court finds that the wrestlers' counsel did not comply with the order and that declaratory judgment, dismissal, and sanctions are warranted. So, ... The lawyers did not do what they were supposed to do. They did not follow federal procedure. So, there it is. It has nothing to do with your rights. Your lawyer sucks. All right, so part 2, background. On January 16th, 2015, plaintiff's counsel, Konstantine Kyros, filed the first of 6 lawsuits on behalf of former WWE wrestlers, alleging they are either suffering from symptoms of permanent degenerative neurological conditions resulting from traumatic brain injuries sustained during their employment or are at increased risk of developing such conditions. As set forth below, this case has been characterized by attorney Kyros' repeated failures to comply with the clear and unambiguous provisions of the federal rules of civil procedure and this court's repeated instructions and admonitions, which has resulted in a considerable waste of the court's and the defendant's time and resources. That is a hell of a rebuke. I'm legitimately hot right now. Like that says a lot. And this is the guy Big Vito said he thanked this guy for his time and effort. And this guy was not following federal procedure the whole time, 6 years. Okay, so these are the complaints against the attorney Konstantine Kyros. The first of the consolidated cases. I have to read the headline because it makes sense if you read the headline. A. Attorney Kyros' attempts to evade the court's jurisdiction. The first of the consolidated cases with lead plaintiffs Evan Singleton and Vito Lograsso purported to be a class action and transferred to this court from the Eastern District of Pennsylvania pursuant to a forum selection clause in contracts signed by each of the plaintiffs. Thereafter, Attorney Kyros filed several purported class actions in districts other than Connecticut, each seeking the same or similar redress for the same alleged conduct as the purported class action pending before this court. Each of these cases was subsequently transferred to this court, with the District of Oregon noting that counsel's choice of forum showed evidence of forum shopping. Attorney Kyros then filed the Laurinaitis action in this district, but which was randomly assigned to Judge Eganton. Thereupon, Attorney Kyros attempted to prevent this case from being transferred to this court, despite the clear and unambiguous language of this district's related case rule. WWE sought sanctions against Kyros due to his persistence in filing suit in courts outside of this district. In the exercise of utmost restraint, the courts denied this motion, but noted that Kyros' actions appeared to be, quote, part of a vexatious and transparent attempt to circumvent two prior decisions by district courts in Oregon and California, either enforcing the forum selection clauses or nonetheless transferring WWE concussion litigation to this district. The court also noted that the plaintiff's forum shopping has forced multiple district courts to exert needless effort to corral these cases to the proper forum. Nevertheless, the court denied WWE's motion for sanctions because Kyros had filed the most recent of the consolidated cases in the correct district. The court noted, however, that it was, quote, open to reconsidering this finding at a later date should Kyros revert to bad habits. B. Attorney Kyros repeatedly files complaints rife with irrelevant, inflammatory, and inaccurate information. The complaints in the initial actions consolidated before this court were nearly identical. They were exceedingly long and consisted of paragraphs asserting generalities, legal conclusions, and facts unrelated to the plaintiff's claims. The court repeatedly instructed Attorney Kyros on his professional obligations under federal rules of civil procedures 8, 9, and 11. For example, in a June 8, 2015 scheduling conference, the court admonished plaintiffs that, quote, the defendant shouldn't have to write a motion to dismiss, nor should the court have to read, research, and write a decision on a motion to dismiss when it's patently clear that the parties prior to filing of this motion that the claim should be dismissed. The court went on to explain that, quote, a complaint should be a compilation of facts. Facts. I'd really like you to read the federal rule, give it some close consideration, perhaps read some cases on the pleadings standards, and then file this complaint again in a week without any scrivener errors, without a lot of superfluous, hyperbolic, inflammatory opinions, and references to things that don't have any relevance. Damn. Just damn. The court specifically noted that Singleton complaint referenced a report that became public in 2014, claimed that the plaintiffs were deceased when they were not. Claiming that the plaintiffs were deceased when they were not, and referenced events that transpired in the lives of wrestlers who were not parties to the lawsuit. The court asked, what does this have to do with either of your clients? They had both stopped wrestling before 2014. I see no reason to include that in the complaint other than to inflame. it's argumentative. A complaint should be a clear and concise statement of the facts that form the basis of your claim. So you need to identify what claim you are asserting, do the research to find out what facts have to be proven in order to establish that claim, and allege the facts that are necessary to prove each claim, because the rest of that is just window dressing. And that is where you get into the trouble that you are in, where you're asserting that someone's dead who's not, because the complaint is full of hyperbolic stuff. It may be clear, but it's not concise and it's not accurate. Let that sink in. It may be clear, but it's not concise and it's not accurate. So what is this lawyer doing? I have no idea. I don't know what this lawyer is doing. The court then granted the plaintiffs leave to amend their complaint, which they did. Despite deficiencies in the amended complaints filed in the Singleton case and others, the court considered WWE's motions to dismiss the complaints on their merits and dismissed claims 1, for negligence for failure to state a claim under Connecticut law, 2, for negligent misrepresentation and fraudulent deceit, for failure to identify with any specificity any false representation by WWE upon which the plaintiffs relied, 3, and for fraudulent concealment and medical monitoring because neither stated a separate and independent clause of action under Connecticut law. The ruling also stated that the complaints were excessively lengthy, including large numbers of paragraphs that offer content unrelated to the plaintiff's causes of action and appear aimed at an audience other than this court. Aimed at an audience other than this court. Thank you, John Oliver and Andrew Yang. Right. A fraudulent omission claim as to plaintiffs Singleton and Lograsso survived the summary judgment stage on the ground that these plaintiffs had adequately alleged that WWE knew of the risk that repeated concussions or subconcussive blows could cause permanent degenerative neurological conditions like CTE as early as 2005, and fraudulently failed to disclose this risk. This is the third complaint against the lawyer. Attorney Kyros conducted during the discovery and summary judgment phases of Singleton. The parties conducted discovery into Singleton and Lograsso's claims, during which WWE attempted to uncover, among other things, the basis for the plaintiff's allegations that 1, Singleton experienced symptoms associated with a traumatic brain injury from which he suffered while wrestling for WWE. WWE made deceptive public statements, quote unquote, which, quote unquote, downplayed known long-term health risk of concussions. 3, WWE attempted to criticize or discredit studies related to brain trauma or CTE. 4, individuals associated with WWE stated, quote, wrestlers diagnosed with brain trauma did not receive these injuries as a result of wrestling for WWE. WWE also sought information regarding the specific fraudulent omissions or misrepresentations that formed the basis of the plaintiff's claims. Plaintiffs were unable or failed to do so. When the plaintiffs served deficient there's a hell of a word. My brain is tired. Interrogatory responses related to these issues, WWE filed a motion to compel, which the court granted in part. With respect to interrogatories, asking plaintiffs to identify a person or statement, the court noted that where plaintiff is unable to identify a statement or speaker in response to this interrogatory, plaintiff must state that fact. I think, okay, let's take it a little bit slower. Plaintiffs supplemented their responses. However, WWE judged that these responses were insufficient and filed a motion for Rule 37 sanctions, arguing that plaintiffs failed to comply with the court's ruling on WWE's motion to compel. WWE specifically asked the court to dismiss the case with prejudice and to award attorney's fees. On February 22nd, 2018, Magistrate Judge Robert A. Richardson issued a ruling recommending that the court order further supplementation of these 6 interrogatories. God damn, what the hell is up with that word? And what the hell was up with my brain? And that the court ordered attorney Kyros and his law offices to pay WWE all of the legal fees that it incurred in connection with this motion for sanctions. While Judge Richardson recommended denying WWE's motion to the extent it sought dismissal with prejudice, which means that it would be unable to refile. I think that's what that means. He noted that, quote, plaintiffs and their counsel are now on notice that any further noncompliance during the remainder of this litigation may result in a dismissal of the case. The court adopted this recommendation ruling on July 22nd, 2018. Shortly after Judge Richardson issued his recommended ruling on March 28th, 2018, the court granted summary judgment as to Singleton's and Lograsso's claims on the grounds that, 1, plaintiffs failed to present any evidence that WWE knew of the risk that concussions could cause permanent degenerative neurological conditions prior to 2007, which was after Lograsso's retirement from wrestling. And 2, WWE offered undisputed evidence that it warned Singleton of the risk before he sustained his career-ending injury in 2012. Wow. The court also noticed that plaintiffs' counsel had once again, quote, asserted facts and advanced legal theories for which there is no reasonable evidentiary and legal claims. And again, quote, cautioned that such conduct subjects counsel to Rule 11 sanctions. The court then advised plaintiffs' attorneys to discharge their ethical duty to the court by, quote, reading the record in its entirety before filing anything with the court to assure their reasonable beliefs in any and all further assertions of fact and law. This document is 40 pages. I've read 8 of them. I think we've read enough, right? I think we've read enough of this stuff. Let's see. That's just the motion to dismiss, okay? So what do we got so far? We've read this thing, and what do we got? We got that the lawyer was not filing the motions correctly, that they had no facts to support their claims, they presented no evidence to support said facts, that they were making, that the lawyer was forum shopping, which is essentially you keep filing lawsuits and you try to find a friendly court in which to file the lawsuit in. Okay, so this guy, this Konstantine Kyros, has done irreparable damage to whatever wrestlers think that they're trying to do when it comes to CTE. Simply put, I don't know how you can continue this argument that WWE did something wrong when you have no facts. I mean, it should be easy to prove. Like I said, intuitively, you would think that pile drivers and hitting people in the head with steel chairs would cause degenerative brain damage. But then again, nobody knew it. Like nobody knew, that CTE was a thing that could happen when The Rock hit Mankind in the head 13 times with a steel chair. Nobody had no idea. Right? And then you also have, situations where they ask, where else have you worked? Have you done anything before or since you went to WWE? And apparently these people did not provide any of that information. So this took 6 years. And Big Vito says, I wanted a hearing. I wanted to be able to stand in front of a jury of my peers. It's like, well, you put your case in the hands of this guy. Well, apparently, because there's 50 different defendants, it's probably been people who just filed the lawsuit and then was hands off and walked away. It happens. People trust an attorney and then they walk away. But also know that Konstantine Kyros had a blog that he was using to put all of the documents and different things like that up. I'll see if I can find that. I'll post that in the description if I can find it. But there's another document that needs to be read that we probably should go through. Let's see if I can find it. Okay, so this is from the United States Court of Appeals for the Second Circuit. This is the appeals that I guess was dismissed. These are the names of the wrestlers that are involved in the lawsuit. William Albert Haynes III, which is Billy Jack Haynes, I believe. Rodney Mack. I'm not going to read their real names if their wrestling name exists. Big Russ McCullough, Ryan Sakota, Matthew Robert Weiss, Luther Reigns, Evan Singleton, Vito Lograsso, Cassandra Frazier, individually as the next of kin to her deceased husband, Nelson Lee Frazier, who was Mabel, Viscera, Big Daddy V, King Mabel. The estate of Nelson Lee Frazier, Timothy Allen, Rex King, Joseph M. Laurinaitis, which is Road Warrior Animal, Paul Orendorff, Ahmed Johnson, Kamala, King Kong Bundy, Ken Patera, Terry Brunk, which is Sabu, Barry Darso, which is Smash, Bill Eadie, which is Axe, John Nord, Johnny the Bull, James Brunzell, which is Jumpin' Jim Brunzell, Susan Green, I don't know who that is, Angelo Mosca, aka King Kong Mosca, James Manley, aka Jim Powers, Mike Enos, Blake Beverly, Bruce Reed, aka Butch Reed, Sylvain Grenier, Omar Mahires, which is Omar Atlas, Don Leo Heaton, or Don Leo Jonathan, Troy Martin, aka Shane Douglas, Mark Kopani, Muhammad Hassan, Henry Godwin, Princess Victoria, Judy Hardy, which is, Judy Martin, Bernard. There's a lot of different people, man. Axel Rotten, Marty Jannetty, Warlord, Barbarian, Rex King, Tracy Smothers, Mantar, Black Bart, Slick, One Man Gang, Jimmy Jack Funk, Rod Price, Don Driggers, Ronald Scott Hurd on behalf of Ronald Hurd, also known as Outlaw Ron Bass, Boris Zukov, David Silva, Johnny Jeter, Balls Mahoney, Ashley Mazzaro, Perry Saturn, Flash Funk, and James W. Snuka. That's everybody that was suing WWE. And all of these people are represented by Kyros Law PC, Konstantine W. Kyros. And there's a lot of people here. It's consolidated plaintiffs. There's a bunch of other people involved. It says appellants. I guess these are the top was the complainants, and the bottom are the appellants. But there's a lot of other people. Superfly Snicker, Chavo Guerrero Jr., Chavo Guerrero Sr., Adam Baum, Dave and Earl Hebner, Jazz. I was just talking about Jazz the other day. Like, she would fit perfectly in the Hurt Business. But I guess she's suing WWE, so whatever. Mark Jindrak, John Heidenreich, a lot of other people. A lot of people, man. A lot of people suing Vince. A lot of people suing Vince McMahon. So these are the consolidated plaintiffs. That's who they are. So let's I've read enough names. Let's get to why the district court threw this out, the appellate court. Upon due consideration, it is hereby ordered, adjudged, and decreed that the appeals of sanctions orders are dismissed. The merits appeals of the dismissal of all claims in Haynes versus World Wrestling Entertainment, McCullough versus World Wrestling Entertainment, Frazier versus World Wrestling Entertainment, Singleton versus World Wrestling Entertainment are dismissed. The judgment of the district court on all claims is affirmed. The appeal arises from 7 cases consolidated in the United States District Court for the District of Connecticut. The cases were sought against World Wrestling Entertainment by former WWE wrestlers. The plaintiffs' appellants alleged that, as a result of physical trauma they experienced while performing, they suffered neurological damage resulting in diseases such as chronic traumatic encephalopathy. In addition, now that word is a lot harder than the word I was struggling with earlier, encephalopathy. In addition to other significant physical and mental health impairments, in each of the cases, the plaintiffs' appellants were represented by the same attorney, Konstantine W. Kyros of Kyros Law PC. We assume the parties' familiarity with the underlying pleadings and their factual allegations and the procedural and substantive rules below and the issues on appeal. 1. The first complaint in the consolidated cases was a putative class action filed in the District of Oregon in October the 14th on behalf of Billy Jack Haynes versus World Wrestling Entertainment. Several months later, in January 2015, former wrestlers Vito Lograsso and Evan Singleton filed a putative class action in Eastern District of Pennsylvania, Singleton versus World Wrestling Entertainment. Both wrestlers had forum selection clauses in their contracts, with WWE, providing that litigation arising from the contract be brought in the District of Connecticut, where WWE is headquartered. The Pennsylvania court enforced the forum selection clauses and transferred the singleton action to the District of Connecticut. In February 2015, the estate of Nelson Frazier, a deceased wrestler, commenced a wrongful death action in the Western District of Tennessee, Frazier versus WWE. In April 2015, wrestlers Russ McCullough, Ryan Sakota, and Matthew Weiss commenced another putative class action, this time in the Central District of California, McCullough versus WWE. Around June 2015, the district court in Connecticut presiding over the singleton action became aware of the pending actions in Oregon, Tennessee, and California. The contracts WWE signed by the wrestlers in each case contained forum selection clauses requiring litigation in the District of Connecticut. All of the actions were eventually transferred to Connecticut, where they were consolidated before the district court. In March 2016, the district court dismissed all claims in the Haynes, Singleton, and McCullough actions for failure to state a claim, with the exception of fraudulent omission claims on behalf of Singleton and Lograsso, McCullough, and the WWE. In November 2016, the district court granted WWE's motion to dismiss the wrongful death claim asserted in Frazier. Frazier, who died in 2014, had been cremated without having any of his brain tissue examined. Frazier's counsel had argued to the district court that CTE can be diagnosed only through a post-mortem examination of brain tissue. Because no examination had been done on Frazier, the court concluded that his estate could not possibly allege that he had CTE. Well, I'd just be damned. They said that he had CTE, burnt the fucking body, and couldn't prove it. Come on, man. That's fucked up. And I'm not on anybody's side when it comes to this. But if he really had CTE, you ruined your opportunity to prove it, and then you went to the courts knowing that you couldn't prove it and thought that you could just get away with that. Come on, man. Come on, bro. That's bullshit. That's bullshit. Let's continue. The court also concluded that Frazier's estate failed to plead any non-conclusory allegations linking Frazier's death to injuries sustained while wrestling. Frazier had died of a heart attack, and the operative pleading contained no allegations that heart failure could result from CTE. God, man. Come on, bro. He had a heart attack. This dude was like 500 pounds for most of his life. That's scary. This is scary stuff. This is silly. Do I need to continue? I'm going to continue to read it because there's more, I'm sure. In a decision filed on March 28, 2018, the district court granted summary judgment on the remaining fraudulent omission claims in Singleton. The district court concluded that the plaintiffs had not produced evidence that is establishing that WWE knew of a risk of permanent degenerative neurological conditions prior to 2017, when a widely publicized report on CTE, the Benoit report, quote unquote, discussed those conditions. The court concluded that no reasonable jury could find that WWE concealed the dangers allegedly associated with wrestling. Wow. That's a stiff shot, man. They working stiff in these courts, dog. They working stiff in these courts. They throwing live rounds, man. They throwing live fucking rounds. I hope y'all not too bored. I hope you're paying attention, because we keep hearing that these guys are not providing any evidence, and that the lawyers are filing lawsuits in states other than Connecticut when the contracts say that you have to file lawsuits in Connecticut, where WWE is headquartered. Okay, let's continue. How long is this document? Oh, this document is 14 pages. I'm already on 7. So we'll see how far we get. Okay, so part 2. After the district court dismissed all claims in Haynes and McCullough actions and dismissed all but the fraud by omission claim for each plaintiff in the Singleton action, the Haynes and McCullough plaintiffs filed notices of appeal in this court. WWE moved to dismiss those appeals on the grounds that the appeals were not taken from a final judgment that disposed of all consolidated cases. A panel of this court, applying the then current law of this court, agreed that the final judgments in Haynes and McCullough could not be appealed until final judgments had been entered in all consolidated cases. Accordingly, the panel dismissed the Haynes and McCullough appeals without prejudice. More than a year later, on March 27, 2018, the Supreme Court held that in consolidated cases such as these, a final judgment in one of these cases is immediately appealable even where final judgments have not been entered in the consolidated cases. Let's skip that. That's what I'm skipping is legal mumbo jumbo. It really is just gonna bore us to death with more legal stuff. Following the decision in Hall, neither the appellants in Haynes and McCullough, nor any plaintiff in Singleton or Frazier sought relief from this court or in the district of this court. This inaction was fatal. Arguments as to Hall's applicability or as to any workarounds have been waived. Hall controls and renders the notices of appeal in Hayes, Singleton, Frazier, and McCullough untimely. Untimely notices of appeal are jurisdictional bars to this court's review. This court has long held that the taking of an appeal within the prescribed time is mandatory and jurisdictional. Accordingly, we lack appellate jurisdiction over the appeals in Haynes, McCullough, and Frazier, and Singleton, and for that reason, those appeals are dismissed. Part 3. In 2016, Laurinaitis versus WWE, a suit brought by 50 former WWE wrestlers, was commenced in the District of Connecticut. The complaint included a number of tort claims and in addition sought relief under various statutes on the ground that in its contracts with the wrestlers, WWE had misclassified them as independent contractors. WWE moved to dismiss the action and the District Court granted the motion, holding that the claims were either time barred by prior rulings, or frivolous. So they played the independent contractors card. How many times have we heard this week? Like, we keep going over this independent contractors thing. Connecticut laws requires tort claims to be brought, quote, within 3 years from the date of the act or omission complained of. The 3-year period, quote, begins with the date of the act or omission complained of, not the date when the plaintiff first discovers an injury. The complaint in Laurinaitis alleges that WWE concealed the risk of that concussive blows to the head could cause permanent degenerative neurological conditions with the aim of inducing the wrestlers to continue performing. The district court dismissed the complaint, reasoning that any concealment of information alleged to have occurred must have occurred at a time when the wrestlers were still performing. And because it was not disputed that none had wrestled later than 2011, their tort claims were time barred. We find no error in the district court's conclusion. Under Connecticut law, wrongful death claims must be brought, quote, within 2 years from the date of death, except that, quote, no such action may be brought more than 5 years from the date of the act or omission complained of. Connecticut law, quote, serve as a bar to a wrongful death claim, even if an injured victim could not have known that he or she had a claim against the alleged tortfeasor until after the limitation had expired. The district court correctly determined that none of the plaintiffs in the Laurinaitis action had wrestled for WWE within 5 years of that filing of that complaint, and thus the wrongful death claims were also time barred. Again, we find no error. The remaining claims are also time barred. The misclassification claims allege that the wrestlers' classification as independent contractors was a part of a scheme to defraud. Even assuming the longer 6-year statute of limitations for contract claims applies, none of the wrestlers plausibly alleged that they were first misclassified within 6 years of the filing of the Laurinaitis complaint. Finally, we affirm that the dismissal of the Plaintiff's Occupational Safety and Health Act, Employee Retirement and Income Security Act, Racketeer Influence and Corruptions Organization, the RICO Act, Family and Medical Leave Act, and unconscionable claims for the reasons stated by this court. Connecticut statutes of repose may, under appropriate circumstances, be told into what this court's term, quote, continuing course of conduct doctrine. recognizing that a period of repose may be told in the proper circumstances, reflecting that during an ongoing relationship, lawsuits are premature because specific tortious acts or omissions may be difficult to identify and may yet be remedied. Appellants contend that it applies in this case. Pursuant to the doctrine, a plaintiff must show that a defendant, 1, omitted an initial wrong upon the plaintiff, 2, owed a continued duty to the plaintiff that was related to the alleged original wrong, and 3, continually breached that duty. Whereas Connecticut courts have found a duty, quote, continue to exist after a cessation of the act or omission relied upon, there has been evidence of either a special relationship between the parties giving rise to such a continuing duty or some later wrongful conduct of a defendant related to the prior act. The existence of a special relationship, quote, will depend on the circumstances that exist between the parties and the nature of the claim at issue. The district court concluded that the Laurinaitis plaintiffs failed plausibly to allege a special or continuing relationship between themselves and WWE, in part because, quote, a mere contractual relationship does not create a fiduciary or confidential relationship. There was no plausible allegations in the complaint that could lead the court reasonably to conclude that WWE had a continuing duty to provide comprehensive health care to the wrestlers after they stopped performing. Likewise, the district court was unpersuaded by the allegation that continuing royalty payments somehow gave rise to a duty on the part of WWE with respect to the alleged misclassification as independent contractors. We agree with the district court, and we similarly conclude that the continuing course of conduct doctrine did not cause the otherwise applicable statutes of limitation or repose to be told. The district court was also correct that the statutes of limitation and repose should not be told under the fraudulent concealment doctrine. Wow, we just going on and on. It's just so much, man. I've read 11 pages of this stuff. I should have just read the conclusion. I really should just read the conclusion. Conclusion. Let's skip to the conclusion. Conclusion. Accordingly, the appeals of the merits orders in Haynes, McCullough, Frazier, and Singleton are dismissed for lack of appellate jurisdiction. The appeal of sanctions ordered in Laurinaitis and Singleton is dismissed for lack of appellate jurisdiction. The judgment of the district court in all other aspects is affirmed. For the court, Catherine O'Hagan, Wolf, clerk. So there it is. There it is. That's Big Vito's big case. They fucked up. The lawyers wasn't that good. Lawyers fucked up. Lawyers fucked everything up. And then they allow statutes of limitations to go by. They filed in the wrong courts. You know, there's just so much here. But ultimately, it had nothing to do with his rights being removed. It had nothing to do with him not having any rights. It's simply the fact that he agreed to something in his contract that he now wish he had not agreed to. And now it's a problem. And now he's trying to hang on to Andrew Yang and John Oliver and hoping that wrestling newsletters will pick it up. And of course, not read any of these documents and try to figure out what's going on. And see, that's the thing about this whole independent contractor thing, man. People get so upset about it without realizing, and I'm gonna editorialize now because I'm done reading these goddamn documents. Why do you want your health insurance tied to your job? That creates a dependence between you and your job. You know, like if you're a wrestler and you have health insurance, that means you have the same health insurance no matter which job you go to. You can go to another job and have the same health insurance. It doesn't change. Like your plans doesn't change. You have a lot of people right now in the world who, you know, they go to work and they pretty much go to work for their benefits. The first starters, they make less money than they should because the employer is going to take less money or going to pay them less money to pay for their benefits. Like, you know, there's people who should be making more money, but because they have benefits, they have money and benefits. So the money is lower. The wage, what they're actual paid is lower because they have to take money and put it towards their benefits, retirement, and all that stuff. So if you're a wrestler, That's the deal that you're trying to make here. You're trying to tell people make less money on the hopes that you can have benefits and retirement and all that type of stuff, as opposed to taking that stuff into your own control, controlling your own retirement, controlling your own health care, and pretty much being your own person. But I do agree with Big Vito with one thing. I do believe that independent contractors are small businesses. You are. If you are an independent contractor, you work for you. You are the business. You need to treat it like that. A lot of these guys, man, if we're being honest, there's tons of fucking stories about some of these guys doing drugs, lots and lots of drugs, and that probably lends to a lot of the brain damage that they have. You know, some of them have been doing cocaine and steroids and stuff like that for years. So it's very difficult, you know, and I do want, now I'm anti-union. I'm virulently anti-union, but I think WWE should do something to help some of the performers that are really down bad from wrestling. For instance, Draws, because Draws got hurt in their ring. Now, I don't know what they're doing for Draws. I don't know how that works out or what's going on with Draws. But I think Draws, or Darren Drosdorf, for people who don't know, the guy who got his neck broken in the ring with D'Lo Brown, he specifically, Owen Hart specifically, people who are injured in their ring, people who died in their ring, or died under contract, like Brian Pillman, I think that they have a moral obligation to do something for those people. But individuals who were young enough to continue to work when they were fired, you know, you were fired at, 36 or something like that. Dude, you have another 30 years of life. You have to be able to go out and, create something completely different. Like, it's one thing if, WWE hires a guy to keep the guy on until he's 60 something. The guy can't reasonably go anywhere else to work. And now you're like, go find some other job, you jabroni. That's something different. If you release that guy and he's 32, 33 years old, he's just going to go work somewhere else. And the moment he do that, he could get them concussions and shit there. That's a completely different ball game. It's the same thing with the NFL. But in the NFL, it's different because there are no other professional football leagues. So if you go to the NFL, you boom, 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 bust your head open, you retire at 25, 26, or whatever. You still got your whole life ahead of you, but you're not likely to go out and start running your head against anything else. Wrestling is different. You probably bumped your head 100 times in small dive bars all over the world. And then you come to WWE, you spend 5 or 6 years there, 3 or 4 years at the most, at the least, 5 or 6 years or whatever. And then you are 32, 33, 36, 38, whatever. And when you leave, and then you go knock your head off in Japan, you go bump your head all over Mexico, you go take bumps all up and down Canada, and then you be like, oh, Vince McMahon owes me money. It's like, come on, bro. That's not how that works. That's bullshit. That's bullshit. All right, so I brought you this because I feel like this is necessary. Sorry if it was boring, but it is what it is. I think like people need to read the documents for themselves. People need to understand for themselves what's going on. All the documents that I can put in the description, I will put in the description. The Big Vito document is it's a screenshot, so I can't put it in the description. But it's on Twitter. It's on Big Vito's Twitter. So I'll probably link to his Twitter page if you want to read it and make sure keep me honest as well. Double check my stuff. If you want to go and look up everything that I've said here, if I'm out of bounds in any way, go for it. I'm not a stranger to being wrong. I don't mind being wrong. I don't mind being called out for being wrong. Because if you get called out for being wrong, it only helps you get right later. So there it is. Thank you guys for listening. Watch and like this video, share and subscribe. Be informed. When people start making public claims, please be informed. Please pay attention to the public claims being made. And then pay attention to the response or lack of response. So before I sign off, there's going to be Andrew Yang's really going to ride this wrestling thing because he's going to do a podcast with a wrestling podcaster. So he's really riding this thing. If he says something, I may watch it, I may not. Probably won't watch it because I very rarely watch interviews. But just for people who might not know, Chris Van Vliet is going to have Andrew Yang on his podcast. So if you're interested in hearing Andrew Yang postulate about wrestling like he knows what the fuck he's talking about, he's probably going to say, oh yeah, my favorite wrestler was the Ultimate Warrior, and then he had a heart attack, and I feel like that's Vince McMahon's fault, whatever. But thank you guys for listening. Like, share, and subscribe. I'll talk to you guys later.